Hi there. In this video, we will continue talking about the services that are offered by the forensic accountant. In the previous video, I talked about remediation, where we provide remedy for the victim about the losses that he suffered from and how the defendant should pay him and what are the process of trying to collect these losses either by freezing orders or confiscation orders or collecting money from the insurance or third party and so on. But now we come to the second part, which is the litigation. And here we need to talk about the criminal and the civil court actions where the forensic accountant will support the plaintiff or the prosecuting attorney by making, like consultation, communication, trying to discuss the evidence and so on. The forensic accountant can be hired as a consultant or expert witness. And here we need to differentiate between the fact witness and the expert witness. And we will talk about them in the coming slide. And also, the forensic accountant during his services should be independent in fact and in appearance from the client, which means the forensic accountant should not be either in investment together with the accountant, the company or the client, or should not have some kind of physical relationship or family ties, because this will impair the independence of the forensic accountant. If the forensic accountant decides to become an expert witness, usually the forensic accountant here is firm or persistent, which we call it tenacious. And here the forensic accountant should be really steadfast in his position and cannot be changed by what he hears from others. Also, the forensic accountant has to look at all the different possibilities and able to see through the illogical or unusual financial information, he will be able to see some kind of conclusion. And the forensic accountant has to be focused all the time on the case and forget about the other side points. And then the forensic accountant is usually gets so excited when he is able to resolve the issue and make the right decision. In the meantime, the forensic accountant can be a fact witness. What do you mean by fact witness? Just testify on the fact, but doesn't provide any opinion. It's not like an expert witness. The fact witness just to explain the fact itself. The expert witness usually become an expert because of his education, his research, his certification, and the number of cases he made before. And all of these can make him qualified as an expert witness. And he has to face two different challenges. The one we call it Dupert rule, and the second one, Fry rule. Dupert rule, it actually challenge the ways that has been used by the forensic accountant. It means that the ways that has been used by the forensic accountant as an expert witness are scientifically solid or grounded. Fry rule, it goes actually into another point, which is the admissibility of the evidence in the court. So the opinion is admissible or accepted in the court if it has general acceptance in the scientific community. The forensic accountant here has to explain the technical issues to those who are orchestrating the broader legal activities. The forensic accountant, as I said, should not have any kind of family relation or investment relation with the client, because this will impair his independence. The forensic accountant should look at all the issues involved in the fraud case. And then the forensic accountant should evaluate the evidence from different angles to make sure that this evidence is admissible to the court and correct. Identify if there is any missing data and keep asking questions. View here, what are the lessons learned? It is essential to read the deposition before we go to the court. So usually the forensic accountant goes time and again through the report before he presented to the court to make sure that he addressed all the different facts and provided all the different evidence, and all of them together, they can make a nice story that can be presented. The evidence should be independent and honest. The conclusion and the opinion should be grounded in evidence that is supportable and defensible. As I said, the evidence itself should have real value that make it accepted in the court. The forensic accountant should identify any assumption behind the conclusion or the opinion. Identify resources used as a basis for the work performed and conclusion, and be aware of any weaknesses and vulnerability that might happen during the investigation. So the forensic accountant has to go through the whole case before he goes to the court and present it to the judge. The forensic accountant will start drafting his letter, which has mainly 4 sections: executive summary, introduction, the body of the report, and then conclusion. At the end, the forensic accountant will put some diagrams, some tables that make it easy for the people to understand the case. Present the analysis and the central issues in the story. It should be grounded on evidence, not hearsay. There should be some kind of documents. And the report facts without bias or commentary is just explaining the facts. Include all the relevant information and make it rigorous so that when it becomes presented, it will be robust. Credibility, and here we make it complicated matter seem simple. So this is, I talk about the credibility of the forensic accountant when he presents the case into the court. The information should be credible, protected by being independent, honest, objective, and ethical, and those are characteristics of the forensic accountant. During experts, it means he is expert in his field, and he actually understands the case very well and the details in this case. Understand how listeners evaluate his work, frame his story, build up his rapport with the audience, and make positive appearance. The deposition testimony, parties to a civil litigation are allowed to examine each other, and this happened before the trial. The deposition that could happen were actually the defendant and the victim. They come with their attorneys into a special room inside the court and they make deposition. They might have a resolution before the trial. They gather testimonial for the deposition. They gather testimonial and documentary evidence. Limit the scope of what witness may say. Test or affirm or confirm theories or hypotheses. Develop a record under oath and freeze a witness testimony until we goes to the trial. Move the case towards settlement or trial. As I said, in the deposition, it's a very informal trial, if you would like to say, and they might come into a resolution and test the expert witness report during that time. Once we go to the court, then we might have 2 different kinds of examination. One, we call it direct examination, the other one, cross-examination. Direct examination, where the intersection of credibility and preparation, heart of the case for the attorney. It goes between questions and answers. And here the forensic accountant has to listen to what has been said and then watch the jury and the judge to ensure they understand what he is saying and nothing is difficult for them from the forensic account terminology. He uses summary and exhibits, as I said, which we usually put it at the end of the report, and try to go through the report point by point and become open-minded, which means understand the view of the other people, but doesn't compromise his conclusion. And try to use some visual aid, as I said, different ways of illustration that can help the jury and the judge to understand his view. Cross-examination here, where one attorney is cross-examining the other attorney. So here, each party will examine the other party. The attorney's goal here is to destroy the expert credibility. We can do that by trying to collect some information that can discredit the expert witness or the forensic accountant from his position, and consequently, his report will be rejected by the court. We select questioning to minimize the damage, and the other person who's cross-examining the forensic accountant might end up to say different questions that their answers will be yes or no. Why we go that way? So that when we make all the questions that will end up by yes and no, and we try to twist the mind of the forensic accountant, then he will lead him to the conclusion of the other attorney. And in this way, we discredit all his findings. The goal of the forensic accountant is to be cooperative, maintain the credibility of the conclusion and the opinion, be alert to reasonable or proper opportunities that might come along the discussion that shows any disagreement or explanation. Here we need to understand in the cross-examination, the other attorney might take one of those paths so that the forensic accountant go to in the conclusion that makes the other attorney happy. So cross-examination comes from the attorney of the defendant, for example, targeting the forensic accountant of this victim, and then try to guide the forensic accountant so that he can come in harmony with the attorney. And by doing that, the attorney will discredit the forensic accountant from any conclusion. One of them is called primrose path, where the attorney of the defendant will keep asking questions that it seems okay, and it might lead the forensic accountant to say yes, 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 and this will lead to the destruction of the report of the forensic accountant. It's a primrose path that will lead to the destruction of the report. Nodding chicken, which means also using yes or no answers, where we can guide the forensic accountant to say yes to all the claims of the attorney, and by doing that, we discredit him. Ask until you admit, it's another way. You have got to be kidding. This means nothing. These are different ways that are used by the attorney to discredit the forensic accountant. When an opposing attorney cannot argue the fact or evidence, he or she will frequently call the forensic accountant credibility into question. So this actually, the attorney of the defendant might do some kind of investigation about the expert witness or the forensic accountant, either in his profession or in his personal history, to show that this forensic accountant cannot be qualified as an expert witness. In this case, the forensic accountant has to present his case in a normal, calm way and in a professional way. So remember here that the other party might discredit the forensic accountant to cancel his claim. In this case, we have to make sure that there is a good internal control inside the company, and the forensic accountant should ensure that the victim has good control system that can help the victim to avoid this kind of fraud in the future. This is in brief what I want to say about the different services that can be offered during the deposition or during the trial, and what could happen during the direct examination or the cross examination. Thank you so much. Bye.